Hello, everyone. My name is Riley, and I am the Digital Content and Media Manager here at GBBC. We would like to thank you for joining Hot Topics in Blockchain Law, a webinar presented by the GBBC initiative, the International Journal of Blockchain Law, also known as IJBL. And for those who are not familiar with the IJBL, it is an open access online journal written and edited by lawyers and designed to help business and non-legal communities better understand the world of blockchain and digital assets. So, as a reminder, this webinar will be recorded, and please submit any questions you have into the Q&A box below. Now, I will turn it over to Andrea Tinianow, GBBC's Chief Legal Officer and Head of Policy Americas, to introduce today's session.
Thank you so much, Riley. Welcome, everyone, and welcome our Hot Topics team. We have a lot to discuss today, so we're going to jump right in. I'd like you to please note that because we do want to have a lively conversation, some of us may take views that we do not necessarily hold personally, so please keep in mind that when views are taken, they may not necessarily be held by the speakers. Before we get started, I'd like to ask our Hot Topics team to please introduce yourselves.
Sure. My name is David Adlerstein. I am a corporate attorney at Wachtell, Lipton, Rosen, and Katz in New York, and I'm a member of my firm's crypto team.
Hi, I'm Laura Douglas. I'm a financial services and fintech regulation lawyer at Clifford in London.
Hi, everyone. Jason Gottlieb from Morrison, Cohen in New York, where I chair our digital assets department.
Eric?
Eric Hess, Hess Legal Counsel. I do digital asset work and TradFi work as well.
Hi, Nick Morgan from Paul Hastings and the Investor Choice Advocates Network in Los Angeles.
Hi, I'm Steve Palley from Brown Rudnick. I'm a partner in the DC office and I co-chair digital commerce practice.
Thanks so much. And now on to our program. We will be covering lawsuits in process. We'll be covering legislation. So let's get started with a recent lawsuit brought by plaintiffs against the Department of Treasury in connection with Tornado Cash, with the protocol. And I'm going to ask David Adlerstein if he could kick off the discussion, and then we will jump in.
Sure. Pleasure to be here. So this is a really important case, which introduces some issues really of kind of first impression for the industry. It's being litigated in the Federal District Court for the West District of Texas. And Tornado Cash is or was a mixing service. And just by way of background for people unfamiliar, crypto transactions are pseudonymous, not anonymous. And so if you can link a person to a transaction, you can basically reverse engineer all of their financial activity. Like if you go into a coffee shop and use crypto to pay for your coffee, someone can see that, okay, that's their wallet. Those are all the transactions they did. So there's a benefit to being able to transact privately, as we all know. And Tornado Cash was a protocol that was decentralized using open source software deployed on the Ethereum network that would allow people to engage in private transactions. And a lot of that activity was legitimate. There was, however, a considerable amount of illicit activity, including by bad actors like North Korea. And so this is an interesting case where you have two competing imperatives. There's a benefit to people in general being able to have financial privacy and to be able to transact privately. But at the same time, the government has a compelling interest in preventing and shutting off conduits for bad actors like North Korea and terror groups to be able to transact and move money around. And so how do you balance those competing interests? And what the Treasury did was sanction through the Office of Foreign Assets Control Tornado Cash as a protocol. And in order to do that, they had to essentially take the position that Tornado Cash is sort of a legal person and that the smart contract deployed on the blockchain is property. And those are questions or positions that have potentially far-reaching effects because we, of course, are now at this like nascent stage in the technology's development where we have decentralized software protocols or performing functions that traditionally would be conducted by centralized parties. So from that standpoint, it's really kind of an important issue for the whole space where the thing is procedurally The litigation was brought by users of the protocol. The case is captioned Van Loon versus Treasury. And there was a complaint. There's already been an answer from Treasury. There have been some amicus briefs that I'd recommend that folks take a look at. Some of the notable ones were from A16Z and also from the Blockchain Association. And basically, they're laying out the issues here that, look, if we're going to take the view that decentralized software is a person, there are just a lot of really significant repercussions from that. And it's almost like taking the view that that like wind or the light of the sun is a person and is subject to
so David, I'm going to jump in.
Yes,
I'm going to jump in here because the Department of Treasury makes some pretty sweeping assertions about what a person is or what an organization is in their briefing, right? I mean, they are very, very expansive. They're suggesting that there's a big organization here. It's an unincorporated association comprised of all the token holders, the founders, the protocol. It's all part and parcel of the same thing. And of course, the plaintiffs, they disagree. And do you have any thoughts on, or anyone else have any thoughts on this? There has to be somebody to regulate and somebody to hold liable.
I'm imagining, so sometimes when I think about software, what I do is I analogize it to things that are sort of tangible in the real world. So I'm imagining a dumpster. Let's say that we're placing it. I am legitimately.
On Colesville Road.
A dumpster actually on Veers Mill Road. And imagining this dumpster.
He's changing it.
The dumpster, you got to keep people interested. The dumpster is placed there by an anonymous person. We don't know. They've disappeared. The dumpster has 2 holes on it, right? On one side, you can put in one currency. On the other side, you can take out another equivalent amount of currency. Nobody knows exactly how it works or how it got there. Is that something? Is the dumpster a person that's subject to OFAC regulations and sanctions? Is it subject to the jurisdiction of a court? I can see like an argument could be made, maybe some sort of in.
Yeah, but the Department of Treasury says we know who did it. We know their names.
Let's change the hypothetical.
Oh, okay, we're changing it. Okay, great. Let's do it.
Like let's pretend like we're back in law school. Change the hypothetical. Is that a way to fix it, or is that going to be viewed by OFAC or a court as just I don't know, some sort of subterfuge? Because really, if you're thinking about software as a thing subject to jurisdiction of a court, in my mind, it is really, in a way, it's an intangible version of something. It's what would happen if it were a tangible thing, if it were a dumpster. That's what I don't know the answer to that question.
Well, the vending machine is what they use in their briefs, but who's up? Who wants to respond?
Yeah, I'll make a couple more points and then I'll yield the floor. So there are also First Amendment issues here because software is speech ultimately, and that's well established. And second of all, there was a DAO. So there was sort of like a group of people involved in the development of the software and with an ability to sort of modify the code going forward. But like just take the case of the code itself in its current permutation, which was available on GitHub that anyone could copy and deploy. And you could call it something other than Tornado Cash. You could call it Dumpster Cash if you wanted. That code is out there, like it can't be unwritten, and it is merely by virtue of having been created by some person, then the thing is like forever tainted, that it has that sort of legal identity that's endemic to the code itself. If we start to take that view, there would be repercussions that reach beyond, this compelling sort of governmental interest in not allowing bad actors to engage in illicit financial activity. Because the whole point of a lot of crypto is to disintermediate and have financial functions performed by software rather than entities. And so if we start to regulate software as an entity, that's an issue that's coming up in other spaces as well, like where you see the SEC trying to apply ATS type regulation to decentralized exchanges. So it's a theme that's going to be repeated kind of again and again. It's important to be thoughtful about it. And not overreach, because otherwise it'll basically like destroy the benefits of the technology if we're going to force everything through centralized rails.
But that's your opinion. Like we yes, absolutely. So let's dig in, because there are so many different sides, and we're so I'm curious. I want to go back to the dumpster, Stephen.
Of course you do.
You might have something
Everybody
to
wants
say.
to go back to the dumpster.
I mean, but we do have the example of the vending machine, because that's really similar. And that I mean, the vending machine is brought by somebody who owns vending machines. Everybody knows how that works. And that's actually the example. But you're just saying it's something shows up out of the blue. What do we think?
Well, I'm interested in I know we're going to talk about litigation, but David mentioned how this case may apply to litigation in other areas. I do find it interesting that the users of Tornado Cash here decided to go on the offensive. They're the plaintiff. Does anyone think that, I mean, and they survived the motion to dismiss, which is kind of remarkable. Is there any broader applicability to that strategy in terms of who the plaintiffs are and going on the offensive rather than waiting for responding to a government claim?
Well, it does. I mean, it's similar to what we've seen a bunch of this actually. It's similar to what Coinbase has done, right? With the writ of mandamus, which we'll talk about later. Doesn't it? It kind of makes problematic the notion that nobody's really involved in the thing if people show up and file a lawsuit.
But I guess if we use the dumpster analogy, and maybe that can stand in as for a DAO, the users of the DAO. You know, I think in some of these cases where the SEC's brought a case against, well, you know, reluctantly might say the issuer of the tokens, the people who've in some cases gotten the most strategic play are not the defendants, but the users, the token holders.
Yeah.
You have issues about how the partnership, if it's going to be a partnership, or how the organization, if it's going to be an organization, is going to be classified, right? If you're thinking about our dumpster autonomous organization here, the question is, who's responsible? Is it the person who set the dumpster out there and who's gone in the wind, so we can't do anything more about it? Is it everyone who now, you know, formed the dumpster collective to vote on what kinds of currency should be in the dumpster? Is it everyone who's used it? Is it everyone who, you know, painted it a pretty color to make it look nicer? Like, who would be on the hook? Who would be responsible? And ultimately, you know, in my view, we have to look to individual actions, because this form of collective punishment, like anyone who came near the thing or touched the thing is guilty, seems like a stretch of, you know, the principles of corporate law that allow us to collectively punish groups of individuals who knowingly choose to form these organizations.
You could use a different, like, there's an alternative theory that I don't think the government has used, which is some form of some nuisance or condemnation type of theory, something that is some sort of in rem as opposed to in personam, where you're effectively suing the thing. Like, you could say the dumpster, a municipality would they would tow it away. It's a public nuisance, right? You don't actually have to sue. So I mean, there's a way in which maybe the way the government is approaching this is wrong, but maybe that wrongheadedness will only be resolved by legislation or regulation, which is fine. We're not going to sue people individually. We're going to say this is some form of a nuisance, and we're going to shut it down that way.
Well,
Although functionally, the Tornado Cash sanction does that, right? Because you can't interact with the Tornado Cash smart contract. I'm sorry, Eric, go ahead.
I mean, there's sort of two aspects to that. So if you're basically saying we're going to tell the ISP to shut down the site, that doesn't prevent it from respawning in another website. So it may be actually pretty hard to shut down the thing if it can just be respawned elsewhere effectively. The other thing I think is problematic from a policy perspective is in the context of the dumpster, what you may be now forcing people in the industry to do is to start to break apart the dumpster into smaller and smaller abstractions, so that you know the engagement is more and more attenuated, and it's harder and harder to find the various participants. That could also get complicated by artificial intelligence that could actually potentially perform some of those functions. Now, again, it makes for a more complicated enforcement pattern, but that's the risk of trying to hold everybody in it collectively liable, because
Eric,
it's just.
I think what you have here is you have the old regime, right? Like, we have to hold, they have what they're working with, person or company, an unincorporated association. they cast the widest net, but they can only get the people they know. And so what that will do is that will force more and more people to be less known, to work in a more anonymous or pseudonymous way. And the technology will enable that eventually. And then we're going to have to change the regime, the regulatory regime, as we're seeing. I mean, right now, though, what we're seeing in most jurisdictions is they're just choosing not to deal with the decentralized aspect. That's what we see with MiCA, right? They grandfathered in all of the native tokens that have no issuer, but they've said, okay, any future tokens, man, we need an issuer. Come on. Yeah. So it's sort of this recognition, or this, what they're saying is right now, we don't think anything can be done in a decentralized way, because we will find that party. And even if you read between the lines, or even in the briefs in the Tornado Cash, they're saying, well, there are validators. The Ethereum validators could choose not to validate. So it seems like they're saying, well, we could always go after those validators and keep them from, like, the plumbing. We'll turn off all the water. There's a flood. We're turning off we're closing down the pipes. I mean, that's really the threat here. That even if at the layer 2 or layer 3, which we're talking about here, these applications are problematic. Well, we'll just, we can always find a person to regulate.
Yeah, I mean, maybe just to jump in from a sort of UK or EU perspective, I mean, I think, as you said, Andrea, kind of the regulators, policymakers here are grappling with the question of what to do with DeFi and DAOs, but they haven't really come up with any real solutions yet. I mean, MiCA, as you say, doesn't really sort of address them. It kind of looks to, who's the gatekeeper. So, here actually trading venues, potentially, if you're going to trade a cryptocurrency, a new one, then you've got to kind of take responsibility. The UK, the Treasury kind of sort of has some discussion on what they might do in future about DeFi, but again, it's quite high level, and sort of it's not really, I think it's, they're still grappling for the answer. And actually, just kind of to pick up on, the legal point, then, I mean, it's interesting. I think there's kind of a difference in approach, that I'm not sure that we have the same sort of, litigation kind of ongoing here to push these issues forward. Instead, the UK Law Commission, or England and Wales Law Commission, kind of put out a paper, call for evidence, last November, saying, hi guys, what do you think DAOs are? Should they be unincorporated associations, general partnerships, some other kind of legal concept? And they're kind of digesting that. But to be honest, that's moving very slowly. So I think it'll be interesting to see, with the case law and the litigation that's going on sort of, across the pond in the US, does that move the conversation a lot faster than what we're seeing here in the UK?
Thanks, Laura. Unless anyone has any final comments, I'd like to move to the next topic. Does that sound good? Okay, yeah. All right, well, the next topic has to do with a startup, Prometheum. It received approval from FINRA to operate an ATS, an alternate trading system, for trading digital assets, including blockchain-based securities. And Eric, can you kick us off on this conversation, please?
Sure. So I'm going to just sort of at a high level address what a special purpose broker dealer is, and why FINRA, why that's a category for broker dealers. So this is a number of years old at this point, and a number of firms applied for it, but it never really went anywhere because I guess there were a lot of concerns with approval, et cetera. But the primary purpose of it was to address the problem with the customer protection rule and the good control location, applicable to securities trading. And the problem is that it relates to sort of a bankruptcy or an insolvency analysis, and where are the assets being held? And because blockchain is sort of being held on electronic ledgers, how do you actually establish that good control location that is required under securities law? That's why we have like the DTC and the NSCC, all those different clearing organizations, et cetera, that hold the assets, et cetera. So that was the primary purpose. Notably, the primary purpose of the SP, special purpose broker dealer categorization, was not to enable broker dealers to suddenly be able to facilitate trading in unregistered securities, right? Or to deem a particular asset that they could now trade, even if it was unregistered. If that were the case, I'd probably leave the digital asset profession and just simply focus on foreign issuers, because it would open up this sort of like massive conduit for foreign issuers from all over the world to suddenly begin trading on these, in this case, they applied for an ATS, but to suddenly now have a much easier access to the U.S. markets for secondary trading, notably. So that was the primary purpose of the special purpose broker dealer. Now, Prometheum received approval for SP for a special purpose broker dealer from FINRA. And typically, when you are opening an ATS, you file your broker dealer application and you continue to advise the SEC. You also submit, obviously, a application for the ATS. But when you get approved as a broker dealer, typically the SEC follows. It'd be very strange for the SEC, not to approve an ATS. If FINRA actually did that, they coordinate on that. So I do expect them to be approved as an ATS. The question is that what can they actually trade? Now, the co-CEO Aaron Kaplan basically said that our compliance department will determine if something's a security and whether we can trade it. Now, this is actually, at first I was like, oh my God, but then I had to go back because it's been around for a few years. It's actually a requirement that you have to make a determination as a security. It's not like a right that you have the ability to sort of deign it a security. So he was technically accurate, but in fact, it's not really that they have the power to say, oh, you're a security, so you can trade on our platform. This was, this was a protection to ensure that there was an assessment that it was a security, which is what broker dealers trade. So, that's sort of the.
But Eric, here's a question for you. Like, all right, they got this approval. They're going to get approved by the SEC. Like, do we care? Like, is this a big deal? Or
I don't think
like,
it's.
Does this move the needle? Like, what's the deal here?
So my view on it is, it based on the laws that exist today and the guidance that we have today, it really doesn't enable a lot. I mean, you've had Securitize trying to trade these. You've had INX also trying to do this type of trading, and it hasn't always been an issue with regards to the good control location. They've sort of managed their way around it, but there's a limited universe of
right. There aren't a lot of digitized securities out there, and there's not a lot of liquidity and a lot of demand, right? I mean,
and if people want to kind of learn about this on their own, SIFMA around the same time as this was adopted, put out this sort of distinction, which I find maddening, but I get it. One is this notion of a securitized token. The other one is a tokenized security. Okay. That's right out the gate. But the idea of a tokenized security is it's a security that's been tokenized, whereas a security token, this was basically saying, well, maybe they're aligning with, they're all securities, but they're tokens, right? So the purpose of the SP special purpose broker dealer was to address tokenized securities. And so, therein lies a problem because, if you're, for broker dealers, et cetera, or ATSs, there has to be disclosures. There's a framework for registering the securities. That's the information that's supposed to be out there so that, that's why you have prospectus delivery requirements. That's why you have PPMs. And just the last bit I'm going to say about this, because we got a lot to cover here today. The last bit about this is it also doesn't address registration requirements under Blue Sky, because if you're not
state law,
because if you're not a tier 2, sorry, everybody, a tier 2 Reg A security, or you're not a publicly listed security, you actually don't have an exemption to go trade. You don't have a federal preemption of state law issues. So if you fall into any of those categories, unless you have a preemption, like maybe you have it, Reg CF or Reg D, unless you fall within those specific categories, which have their own disclosure requirements and registration requirements, you don't get a free pass at the state level. So you have organizations. I find it more interesting what OTC Markets did, Cromwell Coulson's organization, what they're doing, because they have experience in sort of trading these sort of unlisted securities, but they also have a Blue Sky compliance.
So we've got a lot. So thank you so much, Eric. That was really helpful. What we see a lot happening is that people come out there and they make a lot of noise, but it's really not as big a deal as everyone.
You might have said this, and I was arguing with Jason on Twitter for part of this. So You'll forgive me, but isn't one of the problems insurance? There's a mismatch between it's a SIPA, right? Doesn't provide coverage for digital asset securities, and that's one of the problems that remains.
That is, and that also links into some of the similar concerns around good control location.
Right. So it's something that can't be fixed unless that insurance regime is fixed in effect.
Yeah, I mean, I think there's a number of problems to be worked out.
Talk to the T0 people.
Yeah.
All right, so not a slam dunk. I'd like us to now turn our attention to England and the Treasury Committee. They recently published a report. So Laura, if you could just give us a quick update from there, and then what we're going to do, our next step will be sort of a litigation roundup, and led by Nick. So Laura, I'm going to turn to you, please.
Yeah, thanks, Andrea. And I thought this is worth sort of just talking about almost as a bit of myth busting, because I think this Treasury Committee report was published in May, and it's had quite a bit of press, really for the headline, where the report says that they think that retail investing in crypto, unbacked crypto assets, looks a lot like gambling, and maybe it should be regulated as such rather than financial services. So understandably, that got quite a lot of pushback from the industry. But I think it's really important to say, well, who is the Treasury Committee? What does this report mean? So the Treasury Committee is different from HM Treasury. So Treasury Committee is a subcommittee, or a committee with a subcommittee that's kind of, in the House of Commons, UK Parliament. But what they do is they look at what's going on in the world of financial services. They write reports, they can make recommendations, but they don't have any lawmaking powers themselves. So they don't actually put forward the legislation. So the next step for the report is the government has to respond to this Treasury Committee report in July. And we'll see what they say. But in the meantime, I think because this report kind of garnered so much attention, actually HM Treasury themselves, so the government department that actually issues regulations or statutory instruments, they put out a response sort of immediately, which is quite unusual, I think, for this kind of thing. Basically saying, we disagree. We think that actually financial services is the right way to regulate crypto assets broadly. Actually, by the way, have you thought about the tax implications as well? But yeah, so I think, it's a debate. There's been a lot of press about it, but I don't think that it's going to end up, I don't think we're going to end up in the UK in a place where this is actually regulated as gambling. I think we're going to stick with the financial services approach we've seen so far. But just wanted to kind of clear that one up.
Thank you. And you were going to mention one other thing about IASCO, right? One other tidbit.
Yeah, I was just going to say, I mean, if you look at regimes across the world, kind of that we've seen so far for regulating crypto, and IOSCO, which is sort of an international kind of securities standard setting body, pretty much across the board, we're seeing people look at this from a financial services perspective. And IOSCO in particular just published their kind of international recommendations for regulating crypto, again, sort of, taking a very similar approach to, what we see, for example, in MiCA, taking inspiration from TradFi and securities regulation, but with adaptations to crypto and the DLT environment. So yeah, I don't think this is going to be a runner.
Thanks so much, Laura. Just a quick follow-up. You were mentioning the other jurisdictions, and one of the things we had noted was that there seems to be a real sort of a lack on the regulators and the lawmakers' part to want to tackle the decentralized aspect of blockchain, that they're really looking at it as financial, as they do financial securities, and we're sort of wondering about that. I don't know if you have any thoughts from the other side of the pond.
No, I totally agree. I mean, I think it's seen as kind of, it's more difficult. So let's put it to like stage 2. So actually just to like to stick with IOSCO, for example, they specifically said in their recommendations, they're not looking at DeFi, but there's another work stream looking at that. They'll come out with a report later. And I think that's kind of the approach that a lot of regulators have taken so far, including the UK. So as I mentioned, the crypto asset consultation that HM Treasury put out earlier this year focused generally on crypto assets and centralized actors and, you know, how do you regulate the services they provide. There were some chapters towards the end saying, and in the future, we might look at, you know, what do we do about aspects of DeFi to the extent that we think there's still a regulatory gap. So, you know, it's putting the market out there to say we're thinking about it, but we're dealing with the lower hanging fruit first, I think.
Yeah, no, that makes a lot of sense. We're going to pick up that theme a little bit later when we talk about what's happening in the state of New York. But in the meantime, I'd like to turn our attention to Nick Morgan. And I know one thing, whenever you talk to someone about crypto, they always go, that Ripple case, that Ripple case, it's still out there. Maybe you could just give us an update on Ripple litigation and let us know your thoughts. Anyone else, feel free to jump in.
Sure. So Ripple, $200 million in defense costs and counting. So obviously not something that's going to be easily replicated in other cases, but apologies for those who are completely up to speed already on this case, but the SEC sued Ripple a long time ago. They've been in federal court litigation, doing what people do in federal court litigation, which is fighting discovery battles.
It sounds so boring, Nick, the way you're
Well, I'm getting to the exciting part. And then weird things started to happen. And obviously Ripple's got excellent counsel, knowledgeable about some potential soft spots. But so this discovery battle over the Bill Hinman speech. So Bill Hinman had been the head of Corp Fin and gave a speech in which he suggested that not every token is a security. Anyway, so Ripple said, gee, we'd like to know more about that. And just asking for that in discovery in a federal court case is very unusual. Actually getting a judge to agree with you and grant you, as the both the magistrate and the district court judge did in that case, grants you access to these internal communications. I mean, I've been doing this a long time, and including at the SEC, and I've never seen that happen. So that was wild. And so the SEC is very sensitive about these internal communications and letting them loose in the wild. So the case proceeds along, discovery battles and so forth, and then the parties filed cross motions for summary judgment. And again, apologies to the lawyers, but essentially that means we're done with discovery, or at least we've done enough of discovery so that we know what all the facts are. And judge, we don't need a trial. You can just decide in our favor on the basis of these facts. And so both sides, the SEC and the defense, filed these motions for summary judgment. And these are very fact-intensive motions. They've got lots of attachments and declarations and exhibits. Among those many documents were some of these Bill Hinman internal communications and other sensitive documents on both sides. And so both sides asked the judge to deny the public the ability to see them. Again, not particularly unusual in SEC cases or any other case to have documents filed under seal. But here, both parties asked the judge to deny the request to have those documents be under seal. And lo and behold, the judge agreed with Ripple that some of the communications around the Bill Hinman speech and some other documents would not be under seal, and therefore the public will have access to them. I haven't gone to look, maybe someone else on the call has, whether that has actually happened yet. I imagine it'll be well publicized when those documents.
Nick, do you have any early predictions for us?
On the motions for summary judgment? So
yeah, like, what do you think? If you're a betting man, what do you think?
So and I just went through cross motions for summary judgment against the SEC on a Howey issue, and the judge sat on it for a long time, like this. I mean, it's obviously an important case, an important issue. So one possible outcome that would disappoint everyone would be
they go to trial.
Yeah, the judge would say there are tribal issues of fact as to the.
Yeah, he'll probably do, or she'll probably do it. But substantively, who do you think has the stronger case?
Well, as an
putting you on the spot, but you can decline.
Defense lawyer, I think Ripple's got the better case.
Well, one of the interesting counterpoints, though, is that it's true that, I mean, it's really unusual for internal agency material to be turned over. Rarely happens. Kudos to XRP, I mean, Ripple's lawyers for getting that. But the other part of the order was that Ripple had to turn over information about its marketing of XRP to folks. And because of the way kind of crypto Twitter bubble operates and everybody wants to be in favor of Ripple and against the SEC, people didn't actually pick up on the fact that Ripple wanted to keep that stuff confidential. Now, why wouldn't it want the world to know that it was out there marketing this thing? And that's because that runs counter to the narrative that the company doesn't have any control over it.
Right.
So it was honestly more of a mixed bag than cheerleaders. That's the problem with social media is you get a lot of cheerleading, and you know, whether or not a judge in Southern District of New York is going to see it that way. The other thing I would say too, without going to the merits, litigators here will all know this experience. Sometimes a judge will give you everything that you want up until the end. They eviscerate you. And the reason they do that is so they're protected on appeal. It's like, as a lawyer said to me very early in my career, you die 1,000 deaths up there. So like, these are individual battles. I wouldn't actually take it. Here's what I would say. I'm not going to say how it's going to turn out. I have my views. These individual discovery battles don't telegraph how it's going to end. And I can almost guarantee, or maybe I'm wrong about this, I would imagine that whatever happens in SDNY, it goes up to the Second Circuit. So,
yeah. But pun intended, I mean, this case obviously will have ripple effects for the crypto asset industry generally, right? Because this is by far the most heavily litigated case that we've seen. I mean, just for around whether a particular digital asset is a security. And for context, we've mostly seen that through backdoor SEC enforcement actions like in the Wahi case and other things that have come up where the SEC is basically said against you know, without an issuer as a party to the litigation, something as a security. So I think the Hinman documents may be instructive about the SEC's own internal deliberations, particularly around the status of Ethereum and the allegation that the SEC is in the business of picking winners here, which a regulator ought not to do. So I don't think those are public yet. I think they're going to be like poured through with a lot of interest by the whole industry when they come out. And, you know, we've heard again and again from the SEC's chair that the rules are clear. We'll see if the SEC's deliberative process reflects that conclusion or instead shows confusion, and it'll be interesting to tear into.
Here's what's going to happen. If Ripple loses, everyone will say it's very fact specific and they had a lot of involvement in it and the case shouldn't apply to everything else. If Ripple wins, everyone is going to say, this is the key test.
And Stephen, I totally agree. But on the flip side, the SEC will do the mirror image. Of
totally, of course, 100%.
But I actually think it's more nuanced, right? Because I think you know, there's both the primary issuance component and then there's a secondary trading component of it.
Very, very fair.
If Ripple loses on the primary issuance component of it, I don't think it's going to be all that substantive. I do think if Ripple loses on it's the secondary trading of it that I think is significant. Because, you know, that would basically upend a lot of precedent regarding investment contract analysis and potentially shape future interpretations. So then everybody would look at interest at the Second Circuit, but certainly the SEC would be emboldened with regards to secondary trading based on an outcome there.
I feel like Lewis Cohen has just entered the chat.
Yes. Yes, welcome.
I am a student of the ineluctable modalities, but yeah, that's secondary trading is always top of mind for me. So yes,
that's a really good point.
Definitely. All right. So that's yeah, absolutely. So let's move on to the next topic, which is the SEC versus Genesis and the motion to dismiss filed by Genesis and Gemini. So Nick, can you take us on that one too?
Yeah, and my
short, it's a headline, and then
headline, right? My primary goal here is to make Jason blush because they filed a motion to dismiss, which was excellent. So headline is: this is among the family of cases starting with BlockFi where the SEC alleged that a earn or lending or reward program, the program was itself a securities offering, And so the motion to dismiss takes that apart, both on a Howey analysis and a Reeves analysis. So what Gemini and Genesis are saying to the court is jurisdictionally, SEC has no jurisdiction. These are not securities. End of story. But it's interesting. It's interesting on that basis alone, but also interesting because, of course, we have the Block 5 settlement, which kicked off the SEC's usual mantra. Well, look, of course, this is a security. We settled with one party, so everybody else who was running a similar program, you should too. So it's nice to see someone pushing back on that. Also interesting is the context and the portion of the motion to dismiss relating to remedies. This happens in the context of bankruptcy, and really the motions raise the issue of why would you get an injunction here? Why would you harm creditors in a bankruptcy setting by insisting on monetary relief? Judge, it just doesn't make any sense. And so it's going to be interesting to see that play out for all those reasons. And so it's one to keep an eye on. Motion was just recently filed, and we'll watch it. Good luck.
Fabulous summary, and thank you, Jason. We've got a few other items here to cover, some ongoing litigation. We have the writ, we discussed it earlier, that Coinbase filed a writ of mandamus seeking, asking the SEC for those rules. And they said, oh, we need more time. Stephen, I don't know if you have any further thoughts on what we're seeing.
Actually, what they filed was a petition for a writ
petition, that's right. Yes, the petition.
And I kind of like, I love this sort of procedural arcana. Litigators understand this stuff, but there are two different ways you can deal with an agency in the United States. You can either sue them under a variety of theories, including the Administrative Procedure Act, or you can use you can seek an extraordinary writ under the All Writs Act. And writs are these things that existed. Our friend and colleague Laura and her forebears created these things like common law writs, right? And so what a writ of mandamus, when you ask for a writ of mandamus, you're saying to a court, in this context, the government has to do something. They're required to do something and they haven't done it. And we need you to order the government to do something. Another type of writ, people are probably familiar with writs of habeas corpus, where you ask a judge to order that prison, for example, a governmental agency produce the body, produce a prisoner. A writ of prohibition is a writ is a petition for a writ that seeks a court to prohibit the government from doing something. So here, the procedural piece of this is interesting. Last year in July, Coinbase filed a petition for rulemaking, asking with the SEC, asking that the SEC promulgate all sorts of rules about crypto. The SEC didn't act, and so meanwhile, back at the SEC had an ongoing investigation of Coinbase, investigating whether it was acting as an unregistered securities exchange, required to register under the Exchange Act, the 34 Act, and sort of towards the end of it, a couple months ago, the SEC issued a Wells notice, basically saying, we're probably going to sue you. Please, if you like, send us a letter explaining why we shouldn't. Then it's kind of like, I don't know, if you abstract yourself, it's kind of like chess, I guess. The Coinbase, put a bunch of PR, a bunch of stuff, said it's nonsense. The SEC had in a separate case listed some of the assets that are listed on Coinbase in a lawsuit, saying those things are securities. So Coinbase, about a month ago, filed a petition for a writ of mandamus, saying, "Hey, the SEC hasn't made a decision on our rulemaking petition. We want the court to order the SEC to make a decision. And if it's a negative decision, if it's no, that's fine. We'll then take that up. But we can't do anything under the Administrative Procedure Act unless and until they rule. So judge, make them rule. It's been more than 10 months. It's more than enough time. This is not complicated." They said, there are cases in which you can imagine that sometimes it takes the government a long time to do things, like if they're, for example, you need to have complicated scientific decisions or analysis. But here it's unreasonable. And that brief was penned, I think on the brief was now deceased Antonin Scalia, his son, I believe, is listed as counsel. It is actually, I reread it this morning. I'm a little bit skeptical that they'll get the relief they've requested. It's a brilliant brief. Highly commend. Folks should read it. It's a great example of really clear and persuasive legal writing. It probably cost $1 million, 15 pages. Whatever Coinbase paid for it, worth every penny. The SEC responded that mandamus relief is extraordinary. The court shouldn't ordinarily tell the government what to do. It's only been 8 months. Coinbase in a few weeks ago supplemented the record. We need time. And it pointed to cases where it said, there are cases where agency action has taken 10 or 20 years. This thing was just filed. We're considering it. And Coinbase's contention that we've already decided internally to, deny the petition is just nonsense, yada, yada, yada. Look, I thought that was a very good brief too. Should the government really take 20 years to decide something?
Well, the other thing also, Stephen, is that Coinbase wasn't the first. As I understand it, there were others that filed these petitions before.
Yeah.
Before Coinbase. So it's not like it was just been 8 months. It's actually been several years where people have been waiting.
Procedurally, I'm not really sure that matters. Here's what
no,
I think.
It wouldn't matter, but it's disingenuous to say it's only 8 months, right?
Maybe, maybe not. I don't know. I think given what I know about writ practice, I did once back in state court in Missouri, I did once get a writ of prohibition granted where an agency was doing something ridiculous. It was like in a zoning dispute. I think it's always dangerous to make predictions, but I'm gonna take that risk. I think Coinbase is probably gonna lose because it's very difficult relief to get in 10 months. The court's probably gonna say, look, I mean, sympathetic, but that's not a lot of time. And you're right, they did just supplement the record. A couple of lawyers on the interwebs have suggested that the reason why Coinbase has done this isn't because they think they're going to win. They know it's a long shot, but it's to get this out. It's part of a PR play so that
the record.
Maybe Congress sees there's a need for regulation. I think it was Hogan, Jeremy Hogan. I think that's the guy's name. I think he pointed that out. I think it's a really astute observation.
What do you think? What does the team think? Anyone else have any? That was really excellent. Thank you, Stephen.
Oh, you're welcome. My pleasure.
Anyone have any thoughts?
Right. I think 10 months, the court's going to side with the agency, but I do think it may be if the court gives some indication of some type of time frame that might be appropriate, maybe that opens the door for Andrea, the one you were talking about, there was one filed as early as March of 2017. So maybe it opens the door for somebody else to follow.
I just want to mention.
I would add one just empirical thing, which is it's rather clear that the SEC is not about to drop a bunch of prescriptive rules about how the crypto industry can navigate all of the existing SEC rules that apply to traditional finance. That much is clear. Now, the SEC chair himself had expressed openness to that in a public statement that we should look at, for example, our disclosure-based rules around registration to tailor them to crypto assets so that you wouldn't have the rules that apply to a traditional business apply to a software protocol. But none of that has happened. And so, unfortunately, we're at this place where it's just kind of inertia, where to the extent that the market is receiving guidance, it's really through the form of these enforcement actions or threats of enforcement, as opposed to prescriptive rails that parties can navigate. I mean, I think harkening back to what Eric was speaking about, the SEC will probably try to point to Prometheum and say, look, you can comply and there is a way to do this. But unless Prometheum actually really kind of goes live, and I don't know how they're going to solve the conundrum of tokens being unregistered, as Eric talked about, there's really probably not that much to that. So I think frankly, it's just kind of inertia. And these battles are going to continue to rage, but there appears to be inertia on the rulemaking front, at least in the SEC, where we may say rulemaking is from Congress.
Yeah, absolutely.
I think a lot of that business is going to go to Laura and her colleagues in the meantime, because
England,
the regulatory regime there is much simpler.
I just want to just take a quick break here to mention that if you like this kind of conversation, Nick Morgan has just launched a litigation working group to look at a lot of these issues in real time with, attorneys on a regular basis. So Nick, I just want to mention that. And if you're interested in joining the working group, just ping Nick or me or really anyone here or send us a note. So that's something that we will be where we've started. But back to the program. I wanted to mention we have a little bit of time left when we were talking about, concerns about the way legislation is being introduced. The state of New York, actually, I'm just going to skip in the agenda here, because the state of New York is in the process of considering legislation introduced by their Attorney General, Letitia James, which is, if you thought the BIT license, there was a lot there. This new legislation, this proposed legislation, is very concerning. It has some real prescriptive language, proscriptive language, and in particular focuses on lines of business that basically would require exchanges to choose a line of business. Either you're a broker, you can't be on both sides of a deal. You can't. I mean, there's a lot there, and it actually borrows a lot from the securities regulations. So it would make it, I think, would make it very difficult for many or all of the businesses that are already duly licensed in New York to continue doing business there. And I can tell you, I participated on behalf of GBC in a hearing last week in Albany, where the two committees in the Assembly, the Banking Committee and the Consumer Protection Committee, they were really grappling with where there are gaps in the current legislation or loopholes and fraud, and they're considering what they should do. But I think we in this industry need to pay attention to this. Even if this legislation isn't passed, it could have more ripple effects, and others could consider the types of prohibitions raised in this legislation. I want to kick off to David. I know that you've spent some time thinking about this, and maybe you can offer some thoughts about the legislation itself and drill down a little bit, and then also share your concerns. And then everyone, please feel free to jump in.
Yeah, real quick. I mean, first of all, I do want to address something that the regulators are right to do, which is that this space has witnessed some terrible implosions in the last year, particularly of centralized parties. A lot of investors were hurt. There are risks to crypto assets that have become manifest, unfortunately. And so the impulse of regulators to look at the market carnage that we've seen over the last year from things like FTX and to think about ways to protect investors is entirely appropriate. That's within their mandate, so no issue with that. The problem is if the pendulum swings too far, where basically you're going to functionally not allow activity or create a pathway that allows the technology to work because you're going to force it through traditional financial rails in a way that, frankly, like centralizes everything. That's really going to be an issue. And New York, historically, and I'm a New York lawyer. I've lived in this area my whole life, so I've pride in New York. Is for many things, it's been the financial capital of the world in living memory. And for crypto, that's just not the case, including because the BIT license regime is rather rigorous, and there are a lot of activities that New York is just sort of a no-go zone. And if legislation like this were to get traction, I do have concern that it would drive even the incumbents who have gone through the BIT licensure. It would frankly drive them out of the state. They would not be able to conduct activity like the way they do currently. And parts of the legislation just were really over the top. For example, there was a prohibition on influencers promoting crypto to people within New York, and they defined the influencer as people who had as little as like a $25,000 interest in something. So read literally, if you owned like one Bitcoin and you were tweeting that you thought that Bitcoin was a good investment, and people in New York could read your tweet, you'd be subject to like registration in New York.
Yeah, and David, just so you know, that was a question. That very question was asked at the hearing, and the Attorney General, representative, the folks from the Attorney General's office said, yes, you would need to register. And registration with the Attorney General is like, I think like a $300. I mean, it's pretty invasive. There's a lot there.
Right. So, I mean, we need something from the regulators other than like a competition to attempt to be the toughest cop on the beat. I mean, really what I think we need is, let's address the problems. They are real problems. It's correct to respond to them, but at the same time, recognize the benefits of the technology and not have crypto be like yet another manifestation of all of our polarized political debates that we have in this country, because I think there is a middle ground that most lawyers would agree on. And frankly, I think there is a thoughtful path forward. Unfortunately, I don't think that the the AG's bill was the best manifestation of that. Although it's possible there are elements of that would be salvageable, but a lot of it just really went too far and would have the effect of driving activity from the state. And I don't think that's a model we want to see adopted elsewhere.
And it's also important to consider that the same month that they proposed this bill, they also brought the action against KuCoin, which was not significant in and of itself. And certainly Jason can talk to this because he filed a phenomenal amicus brief. But they classified Ethereum as a security. And that means that if any instrument, and they classified it as a security, and they applied that analysis to the Martin Act, which is a very unique act in New York that applies to both not only securities brokers dealers, but commodities broker dealer. The Martin Act is it was never intended to have the teeth that it has, but it does get weaponized on occasion. And the fact that it was weaponized for KuCoin should be concerning. So like I'm actually in the process of advising a number of clients. And one of the things I'm saying is if you do anything at all with crypto, exclude New York completely, because it's radioactive. But Jason can definitely say a little bit more about the Ethereum case, amicus brief.
The New York Attorney General's office is wrong.
And that's it. Okay.
I don't know how much more there to say about that.
But it was a great amicus brief. I encourage everybody to read
Thank
it. I'm a big fan of it.
We in the 3 minutes we have left, does anyone have anything that they want to add or share besides the New York AG bad? We've got some hearings coming up, I think, in DC. We've got we've got stablecoin legislation out there floating around. It's unclear that, again, politicized, one that's sponsored by the Democrats, one by the Republicans. They take a different approach, a lot of really important concepts covered by both, but they can't seem to bridge the gap. In large part, I think it has to do with allowing the states to have more control. That's the Republican legislation allows the states to regulate state-issued stablecoins issued under state law.
And of course, there was the SEC's supplemental release regarding the expansion of alternative trading systems, the Exchange Act definitions. So
Right.
I'll summarize the supplemental release as the follow. A lot of people said, certainly you couldn't mean this as it relates to developers or software or small little things or DeFi or anything. And the SEC said, listen, we're based. We meant that. And anything else you ask, we'll probably give you an answer you don't want. But we welcome your comments. Please comment to us so we can utterly disregard them and probably try to make things worse for you. So that's the summary. There you go.
Right. And by the way, Eric, that brings us full circle to Tornado Cash, because really what that's saying is that, look, you can have a decentralized exchange, but it has to be forced through traditional financial rails, in that you have to have an identifiable party that's a registrant that's responsible for compliance. And basically that would force the whole thing like basically through the model that this is attempting to circumvent. So a lot of people here have used like the horse analogy, but it would be like saying that forget about the car. Like, you're allowed to have an airplane, but the airplane must remain on the ground and be pulled by a team of horses. I mean, that's basically, what that stands for. And there's sort of like no utility to having DeFi if that's how it would work. But the difficult question is, from a prescriptive standpoint, how can you have DeFi while still satisfying the imperatives that drive this area to be regulated as a threshold matter? And that can't be disregarded either. You want to have systems that operate with integrity and that are not susceptible to abuse. Right.
David,
come in,
great
register.
Last words. Wait. I got to wrap it up here because
right.
we're at the hour, and just everybody, David's comments, everybody's comments, fabulous. I want to thank the Hot Topics team as always. You never disappoint. I want to thank Riley Fay and Jackson Ross, my colleagues, for producing this webinar, and thank you for everybody joining. Until next time. Bye-bye.
Bye.